A boss who yells, criticizes work harshly, sets unrealistic deadlines, or has angry outbursts. A manager who only scrutinizes or criticizes employees of a certain race, gender, or age group. And today I'm breaking down the critical legal difference between a hostile work environment and a tough boss. A distinction that determines whether you have a lawsuit or just a job search ahead of you. One of the most common misconceptions I hear from potential clients is that any unpleasant, unfair, or toxic workplace automatically qualifies as a hostile work environment under the law. Unfortunately, that's not how employment law works. Here's the crucial legal distinction. A hostile work environment, in legal terms, specifically refers to harassment that, 1, is based on a protected characteristic, such as race, gender, religion, disability, age, over 40, national origin, or other legally protected status. 2, is severe or pervasive enough to alter the conditions of employment and create an abusive working environment. 3, would be considered hostile by a reasonable person in the same position. This means that many objectively terrible workplace behaviors, while toxic and unprofessional, may not meet the legal standard for a hostile work environment claim. For example, a boss who yells, criticizes work harshly, sets unrealistic deadlines, or has angry outbursts is generally not illegal if they treat everyone this way, regardless of protected characteristic. If you have a supervisor who regularly makes sexual comments, racial slurs, age-based insults, or mocks someone's disability, this is potentially illegal hostile work environment harassment. A manager who micromanages everyone and nitpicks all employees' work is probably not going to be illegal. A manager who only scrutinizes or criticizes employees of a certain race, gender, or age group is potentially illegally discriminating. These distinctions apply across all states, including Alabama, Georgia, Virginia, and California, though California's Fair Employment and Housing Act provides somewhat broader protections against harassment than federal law. Another critical point, in most states, employers are automatically liable for harassment by supervisors that results in a tangible employment action like a firing or demotion. But for harassment by coworkers or customers, the employer is only liable if they knew or should have known about the harassment and failed to take appropriate action. Have you experienced what you believe was a hostile work environment? Comment below and let us know what you did to protect yourself. I'm Cara Fontenot, and I'm a lawyer who only represents employees. Follow me for more content like this.